U.S. vs. Georgia Constitution, Rights, Structure, and Amendment Processes. Introduction. Historically, every country has had to develop its governance framework. A constitution is a legal document specifying how a country should be governed by specifying every citizen's rights, regulations, and requirements. The United States and the state of Georgia have constitutions written in different historical times and contain several similarities and differences. Evaluating the common points, disparities, and amendment processes reveals the merits and demerits of citizen involvement in the constitutional amendment process. Similarities and differences. There are several similarities between the United States and the state of Georgia constitutions. Firstly, both have a Bill of Rights, which is among the key elements in the Constitution. It covers citizens' protections and fundamental rights afforded by the government. Some of the rights described herein include freedom of religion, speech, and association. Secondly, the separation of powers is a common theme in both constitutions, where the government is divided into the executive, judiciary, and legislative branches. Thirdly, individual sovereignty is affirmed in both constitutions, where all political power is said to belong to the people. Despite having these common points, the United States and the state of Georgia constitutions differ in various ways, as described below. One of the main differences between the United States Constitution and the state of Georgia is the length of the two documents. While the former has 7 articles, the latter is more detailed with a preamble and 11 articles. Regarding the scope of authority, the Constitution of the state of Georgia covers the issues relevant to the state and the provisions of its government, while the United States Constitution is all about federal jurisdiction as it describes the structure, powers, and rules governing the federal government. Lastly, the two constitutions' amendment processes differ significantly. The United States constitutional amendment process is complex and lengthy, while the state of Georgia's approach is rather straightforward. The amendment process, ease, and citizen involvement. Changing any part of the Constitution necessitates an amendment process. Article 5 of the United States Constitution states that the Constitution is amended by a congressional or constitutional proposal, which is ratified by at least 3/4 of the members. The state of Georgia follows a simpler process whereby the state legislature makes a proposal that requires the approval of 2/3 of the members in the Senate and House of Representatives. Later, this is subjected to a popular vote determining whether it passes as part of the Constitution. The state of Georgia requires that the public vote for every proposed amendment, allowing for more citizen participation. It is also easier to navigate because it only requires approval by 2/3 of the legislature, followed by the popular vote. In contrast, the United States Constitution is more complex because 3/4 of the states must ratify every amendment before it becomes law, and it does not allow citizen participation. Some benefits of citizen participation include democratic legitimacy and the ability to effectively address local issues. However, relying on the popular vote may be disadvantageous in undermining the voice of minorities. It may be polarized due to media influence and campaigns. Conclusion. In conclusion, the United States and the state of Georgia have constitutions that serve as legal documents describing how the governments ought to govern the people. These documents are similar regarding fundamental citizen rights, powers, and sovereignty. However, they differ in scope of authority, amendment process, and length. Allowing citizen involvement enforces democratic legitimacy but may be disadvantageous in overlooking the needs of minorities.